Welcome to the Estate Blueprint, Planning Your Future with Tom Begley.
Hello, everyone. Welcome back to the Estate Blueprint, Planning Your Future with Tom Begley. For over 30 years, Tom has helped families navigate the legal and emotional terrain of estate and trust planning. I'm Sean O'Connor, and today we're talking about something a little uncomfortable, but incredibly important: how to avoid family conflict when it comes to your will, your assets, and your legacy. Tom, good to see you.
Good to see you as well, Sean.
I know over, more than 3 decades, you've seen some stuff, Let's start, with the big one. Why do so many families end up fighting after someone passes away?
Over the past 36 years, I've had a lot of time to reflect upon it because I've been in a lot of litigation over the years. And you kind of, wonder at one point, when, mom and dad brought these kids into the world, didn't they get along for a while? And I will tell you, one of the interesting things is that when I've been to court over the years, half the time you could see it coming from a mile away. The kids just didn't get along from the time they were 6 and 7 years old. I mean, saying there was going to be a will contest or a guardianship fight was pretty much the same as saying that the sun was coming up in the morning. On the other hand, half the time you would wind up waiting for the judge to come out, and my client would be next to me and look across the court and say, "That's my sister. She was my best friend." So really, it can happen to any family. The things that I see that precipitate it is, first, I guess some dysfunction on the parents' half. There's sometimes where people are, you know, it's when there's unequal treatment. Now, sometimes unequal treatment does make some sense, but a lot of times, uh, there's favoritism that probably should be avoided. However, the big things that have brought people into court are, I think, three. One is we're not as close as we used to be as people. It used to be when, we were born and raised and pretty much grew up and, lived the duration of our lives, like, say, my example in the Philadelphia area. But nowadays, you could have, three kids, one living in New York, the other living in Texas, and the third living in California. So they may have gotten along really well when they were growing up, but they just don't have that same connection, which would be something that would have make somebody think twice about either pulling a fast one or taking someone to court. The other also is we have more that it's being transferred. I mean, we have every generation, there's more and more wealth being transferred to the next. I was growing up back in the 1970s, somebody passed away. Maybe after you paid off the funeral and sold the house, it was like everybody got $10,000 or $20,000 each. I mean, nowadays people are getting hundreds of thousands or millions of dollars, and
Yeah.
that does create something to fight over. The
Yeah.
other thing is that we have people who are just flat out entitled. People think that the world owes them a living. So I think there's a lot of societal and personal factors that have really increased, the amount. And then also, I tell people there are seven deadly sins, but I have come up with the eighth one. I probably should trademark it. It's called rationalization. You're not trying to screw your brother and sister over, but like, for example, when mom had that joint bank account that, had $50,000 in it, that, she put you on to help pay the bills while she was declining. And, mom dies. And instead of putting it back into the pot like mom probably intended, that kid thinks, well, gee, I had a special relationship with mom, or I was helping out mom and she really wanted me to have this. So,
Yeah.
it's just a variety of it's the perfect, bad storm.
Yeah, it is interesting to hear your perspective on the gradual shifts over the course of your practice, and how they mirror what's gone on in society or pop culture and that sort of thing. It is kind of, I mean, there's television shows and movies, about all of this. Of course, we've all seen it. I'm curious, um, what are some of the most common estate planning issues that can contribute, to sibling conflict or litigation? I'm assuming that something wasn't clear or something wasn't attended to properly, and that inevitably would lead to a conflict.
There are certain things that do lead to a conflict. So, number one, of course, is children that are being treated differently. So, you have mom and dad have four children, and when both of them die, the will says that one's either being disinherited or one's getting 10% and the other three are getting 30% each, or usually the alternative that really precipitates it is say, one's getting half and the other three are dividing the other half. So when it's a disproportionate distribution. Now, some people do understand that, but once again, because we live in an era of entitlement, a lot of people don't, and they don't realize that it's mom or dad's wishes. Their idea is that, well, obviously the person who's getting the money did something really wrong, and they must have unduly influenced or taken advantage of their mom or dad to make them write the will that they did. So, one thing that people should do when they're doing their estate planning, and this I go from my line that I tell everybody, it's very important to do the planning properly and not just do the documents, but to make sure the documents work upon death. Is that it's better and cheaper to avoid the lawsuit than to win the lawsuit. So to do that, one thing I've always done when there's a disproportionate distribution is that in between the initial appointment, when I meet with the clients to talk about what I want to have done, and the appointment where they come back and to sign the documents, I do the handful of steps. First, I do a memorandum, which I put inside my database. It says, I met with, John and Jane Smith, and this is why they're doing what they're doing. And I also, to avoid the issue of undue influence, if one of the biggest will contest claims, I will note that they were the only people in the room, and you better not be dumb enough as an attorney to let somebody else in if you want to avoid that claim. And then we talk about the reasons. The second thing I'll do is when they sign the documents, I want to once again note again that, who was in the room, just them, and of course the witness is a notary. And I also want to indicate that, affirm that they were lucid and competent, because the two major causes of action on will contest are lack of testamentary capacity and undue influence.
Right.
The other thing, which is extremely important, is I really insist that when we have the next meeting, that the parents come in with a letter which is written or typed, preferably, written, but that basically states why they're doing what they're doing with the estate plan. And that's important because when mom and dad pass away, the best witnesses to the will contest are obviously no longer available.
Right.
And these are writings that can be used. In 36 years of practice, I've only had 5 wills challenged, and none of them were set aside. But the thing I take greater pride in is that there's probably been at least a few dozen where somebody wanted to file a will contest but didn't because the file was well documented.
Right.
And so what would happen, the typical case is I would get a phone call from the angry attorney representing the angry beneficiary who thought that he or she was short shrifted when it came to the distribution. And then I'd say, well, before you file something, let me send something to you. And then I'll send really the letter that explains from mom and dad, why they did what they did as far as the estate plan. And with only one exception, that pumped the brakes and stopped the
Yeah.
lawsuit from being filed. So it's very important to document, not just do the documents, but to document why you're doing something. Um,
Yeah. Makes total sense. I thought you were going to say that you would insist that your clients, in this case, the husband, wife, mom and dad, uh, let their kids know, like just make sure that they have a conversation, just like, hey, heads up. But obviously, a letter uh, in the file also, serves that purpose and goes even further because you can produce it to opposing counsel if you need, potentially opposing counsel if you need to. So that's
well, Sean, you bring up a really good point. There are times when a family meeting can work. Um, I often tell people not to have the family meeting. I mean, the rare exception is when somebody's older and everything is equal and, folks get along extremely well. And it looks like somebody's going to have to step in maybe to be the power of attorney sooner rather than later. However, sometimes I tell folks not even to have those conversations because even when somebody's getting, or let's say we have 3 kids and it's a third, a third, a third, sometimes one child is upset that the other child's being named the executor, so they feel like they have to be the one to do it. So here's the reasons I often discourage the family meeting. One thing I do tell people is that don't have the meeting, but let the people who are going to act as agents under a healthcare directive, executors under will, let them know A, that they're appointed to act under those rules, and B, where those documents are located. And C, just have the discretion to, keep their pipe shut because we don't want to, poke the bear, as they say, and create a fight that we don't need to create. The problem you have when you are dealing with families is that one person finds out what mom and dad intend to do, but when one of them passes away and let's say the other is incapacitated, all of a sudden you get a phone call from, one of the other children who is disgruntled and they say that mom wants to come in and change her will. And really, when you look at it, mom didn't want to change her will. It was really, the daughter or the son that was walking in because all of a sudden that person's now the agent under the power of attorney, the executor under the will, or, the changes, or there's going to be changes in the division. So I think a lot of those conversations are avoided or those conflicts are avoided when we just keep the children on a need to know basis.
These situations are fraught, difficult conversations to have, and I think that I can imagine, the parents in some of the cases we're talking about here might want to just kind of avoid, you know, getting, designating, so to speak, kind of kick the can down the block, and especially if the siblings get along, and just, we'll let the kids work it out. What's the risk of doing that? I mean, you touched on a couple of things, but
Well, kicking the can down the road can cause some issues. As far as the planning. I mean, the idea is I've had people that die, intestate, that is without a will, and mom and dad think, well, the four kids are going to sit around in a circle and hold hands and sing "Kumbaya, my lord" a few times, and somebody's going to step up and be the administrator. What they don't realize is at first it's cumbersome because you have to get three people to renounce. And if they don't agree, the next thing you know, you've got a court action to decide who's going to be the administrator. Secondly, even if you don't have a court action, you have to get what's called a surety bond, which is an insurance policy to make sure that the administrator properly distributes the value of the estate. So you have an estate that's worth $1.5 million. The administrator has to post a bond, and that's no small amount of money. And I think the kids would rather have the value of the bond added into the estate rather than taken away from it. Sometimes, yeah. So really, there's no benefit to kicking the can down. I think on the contrary, what people need to do is communicate better. So one thing, and I'll give my credit where credit is due, my father, who still at the age of 87 is practicing law, um, basically years ago showed me a thing called a letter of last instructions. And his attitude on that, and he tells every client, and I tell every client, that when somebody passes away, you don't want to play the game of 52 card pickup. So the letter has a handful of sections in it. And one section says, where do I keep my important papers? Where is the will? Where is the advance directive? Secondly, who are the professionals I work with? I mean, who's my accountant? Who's my financial advisor? Who's the attorney? The other question is, if I want to have some sort of, services, whether it's secular or religious based, what I want to have. And the really big one that's happened, I've added over the years, has been the use of digital assets. And that basically is usernames and passwords. I will tell you that sometimes to, get into a company's website to get information, it's like cracking Fort Knox. I've had to actually go to court on more than one occasion to actually get an order uh, and the companies didn't oppose it, but still they wouldn't. They said we need a quarter. And that costs a fair amount of money, and it's a lot of stress that the family doesn't need. So I tell people to keep that up. So the idea is you want to make sure that things are communicated. Another thing that's not very popular is to also plan out funeral wishes as well and make that in writing. In New Jersey, you can appoint your executor under the will to handle the funeral arrangements, even though the will doesn't get probated till about 10 days or so after death. Most people, however, have their burial or services within those 10 days, usually a few days after death and or shorter. Uh, Over the years, I've had a couple things happen because the client will have left their instructions to their family as to what they preferred in their along with the will, which people won't look at till after the funeral. And over the years, I've got some phone calls where somebody said, "Well, gee, I guess mom wanted to use the Smith funeral home, but I actually called the Jones funeral home instead." All right, that's not the worst sin in the world. Although if you pay the Smith funeral home first, it's a little bit of a uncomfortable situation to get the money back. Although you should. The other problem that you generally see, and this is the main, and actually now you can have a separate form in New Jersey and in most states too, where you can designate a funeral agent. Uh, I got a phone call about 6 months ago, and this is when I started using a form that I created on my own because during the call, when I was setting the administration of a father's estate, the son remarked, quote unquote, "I didn't know that dad wanted to be buried." You can't put the toothpaste back in that tube.
No, no, that's undoable for sure. I want to finish up with something on the practical side for someone who's maybe listening, who's worried about potential family conflict, because like you said, people can often you can tell, or you just know there's an existing rift in the family and it's existed for a while. What's your advice to folks like that? What's one simple step they can take to make things easier down the line?
I guess the simple step is to make sure that they individually document what their wishes are and the thought process behind those wishes, and to affirmatively address that discord to make sure that there is no question whatsoever about, you know, the logic behind somebody's, different treatment or even equal treatment. Because once again, I've had people get upset about who's going to be the executor. So, in addition to having a proper estate plan prepared by a competent estate planning attorney, I strongly urge individuals to soundly document their wishes and the basis behind those wishes. Because once again, as I said, after they pass away, they're no longer able to speak for themselves.
Great advice. Well, Tom, great to talk to you as usual.
Likewise, Sean.
For those of you listening, thanks for joining us on the Estate Blueprint. To learn more about how Tom Begley and his team can help, visit the website begley3law.com. That's the number 3, begley3law.com. And if you found today's episode helpful, please subscribe, leave a review, or share a link with someone in your world who you think would benefit from this kind of information. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.